I'm your host, and today, imagine you're looking at a stopwatch, one that starts the very second a child is born.
And as the resident legal expert here, I can tell you that for the next 72 hours, that clock is doing way more than just marking time.
Right. It's actually, well, it's deciding a person's legal fate. Because if a life is taken within that specific 3-day window, the law calls it infanticide.
But the moment you hit hour 73, that charge can instantly pivot to murder or even parricide.
Which is exactly why today's exploration into our source material is so fascinating. We're unpacking a legal briefing covering Articles 255 through 259 of the Revised Penal Code, plus Republic Act 4729.
Our mission really is to clarify these distinctions.
Yeah.
What you'll notice right away is how the law shifts its entire weight based on just a few hours of life and the specific role of the person involved.
But that 72-hour window, it feels so arbitrary. I mean, if you're a prosecutor, you're literally checking a birth certificate against a police report to see if it's, 71 hours or 73. Why draw such a thin line?
Think of it as a legal compromise. The law actually acknowledges the immense psychological and social pressure that hits immediately after birth.
Pressures they assumed would stabilize.
After 3 days, exactly.
Yeah.
If that clock hits 73 hours, you're often looking at parricide. That's the specific crime of killing a direct relative like your own child, which carries a much heavier penalty.
Because it's seen as a violation of that fundamental family bond. Okay, so the timing is huge. But I notice in the sources, it's not just about the clock. There's this requirement of independent life.
Yes. You can't have an infanticide case unless the prosecution proves the child was actually capable of living outside the womb.
So they had to be born alive.
Born alive and reached a developmental stage, usually 7 months or more, where they could sustain life. Without that viability, the legal category completely shifts.
Which brings us to where things get really old school and honestly kind of surprising. There's this concept of concealing dishonor.
Right, the mitigation rule.
Yeah. If a mother or the maternal grandparents commit the act to hide a perceived social shame, the law actually grants a mitigation, basically a lighter sentence.
It is a very specific allowance. Notice how narrow that path is, though. Legislators carved this out only for the mother and her parents.
So if anyone else helps, like a neighbor or a friend, that legal mercy just vanishes for them.
It completely vanishes. It's the law's way of recognizing a very specific type of social desperation, even if it feels outdated to us now.
But wait, I want to go back to that dishonor thing. It creates this weird double standard when we look at abortion under Articles 256 through 258.
It really does. That is the big aha moment in these statutes.
Because if a parent causes a consented abortion to hide that same dishonor before the birth, they don't get the lighter sentence. Why does saving face count as an excuse at hour 1 but not an hour before birth?
The law treats the act before birth, which is defined as the willful killing of a fetus or its violent expulsion, with a completely different set of rules.
Whether it's through violence or without consent or even with consent.
Precisely. The dishonor mitigation simply isn't an option for abortion. The law draws a hard line at the moment of birth regarding what honor can excuse.
It's so interesting that the law shows that sliver of mercy for families because it takes the exact opposite stance when it comes to medical professionals. Article 259 seems to have zero patience for doctors or midwives.
Zero. They face the maximum penalty. The logic is that their scientific knowledge and skills are legally earmarked for preserving life.
So when a physician uses that expertise to do the opposite, it's a profound betrayal of their professional duty. You're held to a higher standard because of what you know.
And that responsibility covers unintentional acts, too.
Right, like if someone uses force on a pregnant woman, even if they had no idea she was pregnant and it results in an unintentional abortion, they're still on the hook.
You take your victim as you find them. If you use violence, you're responsible for the results, even the ones you didn't see coming.
We see that same strictness with pharmacists under Republic Act 4729.
Yes, regarding the regulation of abortives. If you're a pharmacist and you dispense those without a proper prescription, your intent doesn't matter.
You could be trying to help a friend or just being careless. The act of handing them over is where your liability starts and ends.
It really all comes down to the who, the when, and the why. The law is balancing biological reality against these heavy concepts of professional ethics and social honor.
It protects the potential for life while trying to account for the messy, often tragic realities of human social pressure.
It's an intricate balance.
It really leaves you with a lot to think about. We've seen how the law provides that dishonor mitigation for a mother in those first 72 hours, but denies it if the act happens just before birth. What does that say about how our legal system balances the concept of honor against the actual timeline of biological life? That is something for all of us to mull over.
So today, we're going to dive into the incredibly fine lines the law draws around two of the most sensitive topics imaginable: infanticide and abortion. How exactly does the legal system tell them apart? And what does that distinction really say about our society's values? You might think this is a simple question, right? But the law's answer is anything but. It's incredibly specific. The line between these two acts isn't just about what happens, but it's also about when it happens, why it happens, and even who is involved. So let's go find exactly where that line is drawn. So it all boils down to one single massive moment: a live birth. Everything that happens before that point, well, that falls under the laws for abortion. Everything that happens after, now we're talking about infanticide, or in some situations, even murder. That one event changes everything. So to really get a handle on this, we're going to look at 5 key areas. We'll start with this critical 72-hour window right after birth. Then we'll get into the very unique motive of dishonor. After that, we'll compare intentional and unintentional acts, figure out who's responsible when consent is involved, and finally, we'll talk about the special rules for medical professionals. All right, first up, let's dig into the crime of infanticide itself. As you're about to see, the law is obsessed with a very specific ticking clock that starts the second a child is born. For any acts to legally be called infanticide, the prosecution has to prove 2 fundamental things. First, obviously, that the child was killed. But second, and this is absolutely crucial, they have to prove that the child was actually born alive and was viable. That means it could have survived on its own outside the mother's womb. If that child wasn't viable, legally, it's not infanticide. And the law is just incredibly precise here. The label of infanticide only applies if the child is less than 72 hours old. It's not about 3 days, it's exactly 72 hours. Once that 3-day window slams shut, the crime automatically escalates to murder, and that comes with a much, much heavier penalty. Okay, and this is where things get really fascinating and honestly a lot more complicated. The law takes into account this one unique factor that can completely change the legal consequences: the motive to conceal dishonor. This quote here, it really gets to the core of why the law sometimes pulls back a little. It's recognizing the immense psychological pressure a person might be under. That state of panic, the sheer terror of public shame, and it actually considers that emotional turmoil when deciding on the punishment. Now, let's be super clear here. This isn't some get-out-of-jail-free card. It doesn't make the crime go away. Instead, the law calls it a special mitigating circumstance. All that means is that it can reduce the penalty, but, and this is a big but, only for a very, very specific group of people. So look at how this plays out. If you're the mother or even a maternal grandparent and you commit this act to conceal dishonor, you might get a lesser penalty. But for anyone else, a friend, a different family member, a stranger who's just trying to help, the charge is murder, period. It doesn't matter what their motive was, the law makes 0 exceptions for them. All right, so let's hop back over that dividing line of birth and take a look at abortion. In this territory, the law draws another really critical distinction, and this one is all about intent. So, legally speaking, what is abortion? Well, the definition is pretty straightforward. It's either the willful killing of a fetus while it's still inside the uterus, or it's the violent expulsion of that fetus from the womb in a way that ultimately causes its death. And the law basically breaks this down into 2 main buckets. You have intentional abortion, where the clear goal is to end the pregnancy. And then you have unintentional abortion, which is seen as a tragic, unplanned consequence of some other act of violence against the pregnant woman. When we talk about intentional abortion, the law points to 3 specific ways it can happen. First, through direct physical violence. Second, by giving the woman drugs or other substances without her consent. And third, by actually causing the abortion with her permission. And get this, there's a really surprising legal twist that came out of a case called U.S. versus Jeffrey. It established that in cases of unintentional abortion, the kind that happens because of violence, the person who committed the violence can be held liable for the abortion even if they had no clue the woman was pregnant. Claiming you didn't know is not a valid defense. Which naturally leads to our next big question: when an abortion is consented to, who exactly does the law say is responsible? When it comes to a consented abortion, the law doesn't just point a finger at one person. Nope. The liability is spread around. The pregnant woman herself is liable, the person who actually performs the abortion is liable, and even the woman's parents can be held responsible if, and this is specific, if they were involved to conceal her dishonor. And this is a really subtle but incredibly important difference you have to catch. Remember how the concealing dishonor motive could lighten the penalty for a mother or grandparent in an infanticide case? Well, that same leniency does not exist here. If parents cause an abortion to hide their daughter's dishonor, the law offers no such break. All right, for our final piece of this puzzle, we're focusing on a special group of people, medical professionals. And believe me, the law holds them to a much, much higher standard. The law basically says if you're a doctor or a midwife and you use your scientific skills to cause or even just assist in an abortion, you are facing the maximum penalty. Your expertise isn't a neutral fact. In the eyes of the law, it's an aggravating factor that actually makes the crime worse. And this quote from Albert, wow, it just nails the thinking behind this. The law sees it as a profound betrayal when knowledge that's supposed to preserve life is used to end it instead. And that's why the punishment is so severe. And you know what? This web of liability doesn't stop with doctors. It even pulls in pharmacists. An abortive is just any substance used for this purpose. If a pharmacist hands one over without a proper doctor's prescription, they're liable. It doesn't even matter if they knew what the buyer was planning to do. Just improperly dispensing it is the crime. So, to wrap it all up, what have we learned? This entire legal structure is really built on 4 pillars. First, timing. Are we before birth or within that 72-hour window after? Second, intent. Was this the goal all along? Third, the actor. Are we talking about a mother, a stranger, or a doctor? And finally, motive. Does that very specific concealing dishonor circumstance apply? And all of this really leaves us with one big, lingering question, doesn't it? In crafting all these detailed, complex rules, how is the law trying to balance the scales of justice, mercy, and medical responsibility when it comes to these deeply, deeply human tragedies? It's a tough balancing act, for sure, and there are absolutely no easy answers.
Welcome back to the deep dive. You know, usually when we sit down to record these, we are looking at something like, I don't know, the history of the Silk Road,
Right.
or maybe the sociology of social media algorithms, topics that feel really big and sprawling. But today
Today is different.
today we are doing something very different. We are zooming in, way in.
We really are. We are looking at a very specific, a very technical, and honestly a pretty heavy slice of the legal code today.
Heavy is the right word. We are basically staring into the abyss of criminal law.
Mm-hmm.
And I don't mean the TV drama kind where someone yells objection and then the credits roll. I mean the messy, really complicated, how do we define a human life kind of law.
Exactly.
Specifically, we are looking at crimes against persons.
But not just any persons. We are looking at the crimes that happen at the very, very beginning of life.
Right.
We are analyzing the legal definitions, the strict distinctions, and the penalties surrounding infanticide and abortion.
And before you, the listener, tune out thinking this is just going to be a dry recitation of article numbers and Latin phrases, let me just stop you right there.
Yeah, please don't tune out.
Because as I was reading through this massive stack of sources, the case law, the penal codes, all the commentaries, I realized something. This isn't really about law, not at its core.
No, it's about society.
Exactly. It's about how we as a society draw lines in the sand.
It is about boundaries, moral boundaries that basically become legal boundaries.
So let me ask you a question to kick this off, just to set the stage for you listening at home.
Go for it.
Imagine a timeline. Conception is at 0. Birth is at 9 months. At what exact moment, down to the hour, does killing a fetus stop being abortion and start being infanticide in the eyes of this specific penal code?
See, that is a question that stumps a lot of people.
It stumped me.
Right? Because most of us assume it's just about the act of birth. Once the baby is out,
Yeah.
it's a person.
Right.
It's murder.
Right. That's the common sense approach.
But the law we are looking at today, specifically Articles 255 through 259, it has a very specific stopwatch running.
A stopwatch. That is the perfect way to put it.
It really is. It's not just about biology. It's about a legal clock.
So that is our mission for this deep dive. We are going to completely unpack what we're calling the 72-hour rule.
Mm-hmm.
We are going to explore why a mother might actually get a lighter sentence for killing her own child if she's trying to conceal dishonor.
Which is a wild concept to modern ears.
Totally wild. And we'll look at why that same excuse doesn't work if she has what the law calls a bad reputation.
We'll definitely get into that. And we will see how the law distinguishes between a doctor who uses their skills for evil, a truck driver who drives recklessly, and a man who points a gun at a pregnant woman.
Spoiler alert on that last one, by the way. If a man points a gun at a pregnant woman and she is so scared she loses the baby.
That might not be abortion.
Which just blows my mind.
Technically, under the precedents we have here, it really might not be. And explaining why the law makes that distinction is going to challenge a lot of your modern assumptions about biology and trauma.
Okay, so let's unpack this. We have a thick stack of legal texts, case studies, and definitions in front of us. Let's start with the first big category, Section 1, Infanticide, Article 255.
Right, Article 255. This really is the cornerstone of our discussion on newborns today.
The definition seems simple at first glance, right? It's the killing of a child, but it's the fine print that actually gets you.
Always the fine print.
What creates the specific crime of infanticide versus, say, parricide or murder? Because if I kill a 10-year-old, that's murder, or parricide if it's my own kid.
Correct.
But if I kill a newborn, it's infanticide. Where exactly is the line drawn?
It is entirely about the time frame. Legally, for a crime to be designated as infanticide under Article 255, the deceased child must be less than 3 days old.
3 days.
Exactly.
Yeah.
That is exactly 72 hours.
72 hours. Okay, so let's play out the scenario just to make sure I have this right. If a father kills his child who is 71 hours old,
That is infanticide.
and if the child is 73 hours old,
Then it ceases to be infanticide in the technical sense. It reverts to parricide or murder, depending on the exact relationship.
that feels incredibly arbitrary.
It does feel that way.
I mean, biologically, a baby at 71 hours and a baby at 73 hours are identical. They are the same. Why does the law care about those 2 hours so much?
It connects to the psychological state of the mother and the immediate family following birth. The law is acknowledging something medical called the puerperal state.
Puerperal state. Break that down for us. What does that mean?
It refers to the immediate postpartum period. So think about the physical exhaustion, the massive hormonal crash, the emotional turbulence that immediately follows giving birth.
Right, it's a huge trauma to the body.
It's a period of immense instability. So the law historically assumes that in those first 3 days, the mother is in a state of unique, intense stress. She isn't fully herself yet.
So the law is essentially saying, we recognize that you are going through a biological hurricane right now, so we are going to categorize this crime differently.
Exactly. It views the first 3 days as a kind of twilight zone of liability.
Okay, but does that mean the punishment is less?
Well, no. The penalty structure is generally the same. It's extremely severe, usually reclusion, perpetua, or even death, depending on the era of the code you are looking at.
Yeah.
But the classification changes. It's a way of cataloging the intent and the circumstance of the crime.
But there is a massive exception here, a big but.
Yes, there is.
We can't talk about infanticide without talking about the motivation. The source material specifies that this article applies when the killer is a parent or a grandparent. But there is a specific mitigation, a reason to actively lower the penalty, baked right into the text of the law.
You are talking about the concept of concealing dishonor.
Yes. This part really stuck out to me when I was reading. It feels like we are stepping into a time machine. The law actually says, essentially, okay, you killed your newborn, which is horrific. But if you did it because you were ashamed and didn't want the community to know you had this baby, we will go easier on you.
Essentially, yes. If the mother or the maternal grandparents commit the crime to conceal the mother's dishonor, the penalty is actively lowered.
Wow.
It usually drops down to prison mayor, which is significantly less severe than the penalty for parricide or murder.
We really have to pause on that. Concealing dishonor, it puts such a massive premium on reputation.
It does. It reflects a very historical legal system that values social standing and the family name almost as much as human life itself.
But wait, notice you emphasized maternal grandparents just now.
I did. Good catch. The law is very specific on this point. This mitigation is about the mother's shame. So who shares that shame most directly in the eyes of this traditional legal framework?
Her parents.
Her parents, the maternal grandparents.
Okay, so let's hypothesize for a second. Let's say the paternal grandparents, the father's parents, find out about the baby. They are horrified. It's a huge scandal. So they kill the baby to hide the scandal. Do they get the discount?
Generally, no. No mitigation for them. They face the full weight of the law.
Why? That makes no sense. It's still a scandal for their family.
Because the law assumes the actual stain of dishonor. An illegitimate pregnancy, for instance, attaches primarily to the woman and her specific lineage.
Ah, so it's very gendered.
Highly gendered.
Yeah.
The paternal grandparents are seen as being one step removed from that visceral social shame. They aren't protecting their own honor in the same direct biological way the maternal grandparents are.
That is such a fascinating, if somewhat grim, window into how the law views lineage. It's like the shame strictly travels down the maternal line.
Precisely. That is how the legal framework conceptualizes it.
Let's look at a case study, because the sources gave us a really grim but highly illustrative one, U.S. versus Vedra.
Yes, the Vedra case.
This is from the Philippines jurisdiction, likely early 20th century, based on the citation style in our sources.
It's a textbook example of intent and the chaotic moments right after birth.
The facts here are, well, they are difficult to hear, but we need to go through them to really understand the legal reasoning the court used.
Agreed. In this particular case, a mother gave birth. Almost immediately, in a state of absolute panic, she took the infant. She didn't clean it, didn't swaddle it. She took it and buried it in a nearby place.
She buried it alive.
Yes. And the forensic evidence was absolutely key here. When the authorities eventually recovered the body, the child had specific abrasions on both sides of the nose.
Which suggests what?
Pressure, suffocation. The court ruled that the abrasions were likely caused by pressure exerted by another person, presumably the mother, to stop the baby from crying or breathing before burying it. The child ultimately died of suffocation.
That is just brutal. I mean, imagine the sheer desperation, but also the extreme violence of it.
Yeah.
So did the court apply that concealing dishonor logic here?
They analyzed it extensively. The court, and they were referencing the legal commentator Viata here, recognized that in these intense moments, a mother might completely lack the time to reflect on her actions.
Yeah.
She is acting under what they call excitement and obfuscation, driven solely by the terrifying fear of public shame.
Excitement and obfuscation. That sounds like a legal euphemism for a massive panic attack.
In a way, it is. It means your judgment is completely clouded. You aren't thinking clearly. You're reacting to a primal fear of social ostracization. So while she was definitely guilty, the law recognizes that specific motive as being distinct from cold-blooded, calculated murder.
But and here's where it gets really interesting for me. There is a catch to this dishonor defense.
A very big catch.
You actually have to have honor to begin with.
Exactly. This is the good reputation requirement that was pointed out by the legal commentator Albert in our notes.
Right.
The source explicitly mentions that a delinquent mother in the example given is quite dated but legally relevant for the text. A prostitute cannot claim this mitigation.
So let's make sure you and I and the listener really understand this. If a woman who is a known sex worker gets pregnant, has the baby, and kills it to hide it because she doesn't want the burden of motherhood.
The law says she absolutely cannot claim she did it to conceal dishonor.
Because in the eyes of the law,
She has no honor to conceal.
that is wild. It really shows how the law isn't just about the physical action someone takes. It's about their social standing before the action even happened.
It is a stark reminder of how moral judgments are permanently written into these statutes. If you are already seen as fallen by society, the law actually offers you less mercy than a woman perceived as virtuous who makes a desperate, terrible mistake. It literally quantifies the value of your reputation.
It's basically the court saying you can't ruin a reputation that is already ruined so you don't get the legal discount.
Precisely. It's a very cold, hard logic.
Now, what about accomplices? Let's say I'm the mother, I'm panicking, I desperately want to hide my shame, and I call my sister-in-law. I say, please help me, I need to get rid of this baby. My sister-in-law steps in and kills the baby for me. Does she get the mitigation?
No, she does not. And we actually have a specific case for that scenario too. People versus Jaka and Rossalon.
Break that down for us. Why wouldn't she? She's helping the family hide the shame.
Well, in this scenario, the sister-in-law is legally considered a stranger in the context of the dishonor.
A stranger, even though she's family.
Yes, legally speaking. Even if her motive is entirely to help the mother, she is not the one actively bearing the biological shame, nor is she a parent or grandparent.
So she is just a third party in the eyes of the court.
Exactly. Therefore, if a stranger like the helpful sister-in-law kills the baby, she's fully liable for murder.
Murder, not infanticide.
Likely murder because the unique mitigation of concealing dishonor is deeply personal to the mother and her parents. The stranger doesn't get to borrow that emotional defense.
That seems completely backwards when you think about it. The person whose baby it is, the one who actually caused the situation, gets off lighter than the person who just steps in to help them.
It does seem counterintuitive, but it highlights that the law views the mother's mental state, that unique excitement and obfuscation, as something that cannot be transferred to anyone else.
Right.
The sister-in-law wasn't the one who just physically gave birth. She wasn't the one facing the direct social stigma. She had the full mental capacity to think clearly, to step back and say no, and she didn't. Therefore, her culpability is much higher.
It's a really fascinating look at how we judge state of mind. Okay, before we move off infanticide entirely, we have to define the actual victim.
The child.
Right. We said a child less than 3 days old, but what actually counts as a child in this context?
Well, the child must be born alive.
Which seems obvious, but I guess you have to rigorously prove it in court.
You absolutely do. In the case of U.S. versus Aquino, the ruling heavily emphasized that the prosecution must definitively prove the mother gave birth to a living creature. If the child was born dead, if it was a stillbirth, you cannot commit infanticide. You simply can't kill what isn't already alive.
And alive has a technical legal definition too, right? It's not just about finding a heartbeat.
It comes down to the concept of viability. The source cites the case of People versus Detablan, which states that a 6-month-old fetus generally cannot subsist by itself outside the maternal womb.
It can't survive independently.
Right. So if a fetus is expelled at 6 months and dies because it physically cannot survive the outside environment, that is not infanticide. That act falls under the laws of abortion.
Okay, that is the perfect bridge to our next section, Section 2, Intentional Abortion, Article 256.
This is where we shift our focus from the newborn infant to the fetus.
So we just established the boundary line. If it's viable and independent, it's infanticide. If it's not viable, it's abortion.
Generally speaking, yes. The legal commentator Guevara, who is citing Carrara, defines abortion as the willful killing of the fetus in the uterus, or the violent expulsion of the fetus from the maternal womb, which results in death.
But there is a really tricky exception to the viability rule, isn't there? What if the fetus is full term, say 9 months, totally ready to pop, but just isn't born yet?
Good catch, yes. If a full-term fetus is killed via violence or drugs before birth, or if it is expelled and dies as a result of those acts, it still counts as abortion.
Even if it definitely could have survived on its own.
Yes, because the crime of infanticide strictly requires the child to be completely born. So location matters immensely here. Inside the womb, abortion. Born in less than 72 hours old. Infanticide.
So geography really is destiny here.
In a strict legal sense, yes. The womb is effectively a separate jurisdiction.
That's crazy. Now let's talk about how this crime is actually committed. The law breaks it down into very specific modes.
We have 3 main modes outlined in Article 256. First is using violence upon the pregnant woman.
Meaning physical force,
Yeah.
beating, striking, that sort of thing.
Correct. Second is acting without violence, but crucially without the woman's consent. This usually involves administering drugs or toxic beverages.
Like slipping something into her drink when she isn't looking.
Exactly. Or deceiving her into taking a pill she thinks is vitamins.
Yeah.
And the third mode is acting with the full consent of the pregnant woman.
So if the woman goes to someone and says, please help me end this pregnancy, and the practitioner agrees to do it, that falls under the third mode.
Precisely. And the penalties shift in scale depending on which mode is used. But there is a very interesting legal nuance regarding the stages of execution.
The stages.
Yes. We have consummated, frustrated, and attempted.
Consummated means the fetus dies. That part is pretty clear.
Right. Frustrated is where the offender performs all the acts of execution. They did absolutely everything they intended to do, but the fetus somehow survives due to causes entirely independent of their will.
Like they administered the full dose of the drug, but the fetus was incredibly resilient and somehow survived it.
Yes. Or the woman's body naturally neutralized the toxin faster than expected. And then attempted is where they start the process, but are stopped or don't finish the acts for whatever reason.
But here's where it gets really technical and a bit confusing in the notes. The source material mentions a specific hypothetical scenario. What if I use violence against a pregnant woman? I do not intend to cause an abortion, but I hurt her, and the fetus ultimately survives.
This is a classic legal logic trap. Listen closely to how this works. If you use violence, and you did not actively intend to cause an abortion, and the fetus does not die,
Okay.
there is no such thing as frustrated unintentional abortion.
Wait, run that by me one more time. Why not?
Think about the actual words. Frustrated implies you actively tried to do something and failed. Unintentional implies you didn't try to do it at all.
Oh.
You logically can't fail at something you weren't actually trying to do.
Ah, I see it now. So if I punch a pregnant woman because I'm just angry at her, but I don't specifically want the baby to die, and the baby doesn't die.
Then you haven't committed any form of abortion whatsoever. You have simply committed physical injuries against the woman.
Because the abortion didn't happen and I didn't want it to happen in the first place.
Precisely. The crime is defined by the combination of the result and the specific intent. If both of those are missing regarding the fetus, the crime is solely against the mother.
That makes sense. Which leads us right into probably the weirdest, most complex part of this entire deep dive. Section 3, unintentional abortion, Article 257.
This is definitely a category that surprises people when they first study it. Unintentional abortion.
The core concept here is you use violence on a pregnant woman. You do not mean to cause an abortion, but oops, an abortion happens anyway.
Correct. But the absolute key word there is violence. And the legal definition of violence here is incredibly strict and rigid.
This is the story I tease in the intro. The Spanish Supreme Court precedent from way back in 1887. This feels like a classic law school exam type of question.
It really is, the famous man with the gun case.
Walk us through what happened.
So in this case, a man points a gun directly at a pregnant woman. He threatens her life. But he doesn't shoot her. He doesn't strike her with the gun. He literally just points it at her. Naturally, she is completely terrified.
I mean, I would be too. Anyone would be.
The immense fear, the shock, the massive physiological stress causes her to miscarry. She suffers an abortion.
Now, common sense says he obviously caused that. If he hadn't pointed the gun and threatened her, she would still be happily pregnant. He's guilty of abortion.
Common sense says yes, absolutely. But the law says no. The official ruling was that he is guilty of making threats, but not guilty of abortion.
Why? That just feels so wrong on a human level.
Because the law explicitly requires actual physical force. Violence, strictly in the context of Article 257, implies physical contact. The bullet didn't hit her body. The metal of the gun didn't strike her skin. The abortion was caused by fear, a purely psychological state, not physical violence. Therefore, under this very specific, strict interpretation, the elements of unintentional abortion were simply not met.
That feels incredibly scientifically outdated. I mean, we know now how stress hormones profoundly affect the body. We know cortisol can severely constrict blood vessels.
It is absolutely a product of its time, 1887. But it perfectly illustrates how penal codes heavily rely on strict statutory construction. If the text implies physical force, psychological force, no matter how devastating the outcome, might not count for that specific crime. The law demands tangibility.
Okay, let's compare that to a case where physical force actually was used. U.S. versus Jeffrey.
Yes. In that case, a man violently beat a woman. Specifically, he struck her on the hip with a bottle.
A bottle to the hip.
Right.
Not exactly a surgical strike on the womb, right?
No, not at all. And importantly for his defense, the accused claimed he didn't even know she was pregnant at the time.
I didn't know she was pregnant. Seems like a pretty standard defense. I just meant to hit her, not the baby.
Well, the court didn't buy it. Or rather, the court basically said it didn't matter at all. The ruling was that his ignorance of the pregnancy was totally immaterial. Because he intended to commit a crime, physical assault, he is legally responsible for all the direct consequences of that unlawful act.
This is the principle of el que es causa de la causa es causa del mal causado. Basically, he who is the cause of the cause is the cause of the evil caused.
Exactly, a classic doctrine. Even though he hit her hip and not her stomach, the physical violence caused a severe hemorrhage and subsequently a miscarriage. Because he used actual physical violence, unlike our gun-pointing man, he is fully liable for unintentional abortion.
So the bottle actually made physical contact. That's the defining difference.
Contact is the absolute key.
So if you touch her and she miscarries, you're on the hook for abortion. If you just scare her to death without touching her and she miscarries, you might literally walk away with just a threats charge.
In this specific jurisprudential framework, yes, that is exactly how it works.
Let's look at another scenario to test this. Reckless imprudence. The truck driver case. People versus Jose.
This takes it completely out of the realm of intentional assault and moves it into negligence. A truck driver was driving recklessly and violently hit a calesa, a horse-drawn carriage.
A calesa. That definitely dates the case, but the basic physics of the crash are timeless.
Right. A passenger inside the calesa was 6 months pregnant. The sheer impact of the crash threw her off her seat, and she forcefully bumped her abdomen against the front wooden wall of the carriage.
And as a result, she lost the baby.
3 days later, yes, the abortion followed. So the driver was officially charged with reckless imprudence resulting in unintentional abortion.
This is fascinating to me because the driver didn't actually touch the woman himself. The truck hit the carriage, and then the carriage hit the woman.
But the chain of causation is unbroken and clear. His reckless act, the bad driving, initiated the sequence of physical force that ultimately led to the death of the fetus. It wasn't just abstract fear like the gun, it was a physical impact directly caused by his negligence.
It seems like the law is really trying its best to categorize every single possible way a fetus can die. We have intentional killing, we have accidental killing during an assault, we have reckless driving. But what about when crimes get really complex? Like, what if you kill the mother and the baby dies too?
That falls under what we call a complex crime. For example, look at People versus Ganovs. An extremely angry man repeatedly struck a pregnant woman with his fist.
Which is horrific.
Truly. She suffered a massive hemorrhage. She was actually carrying twins at the time. One was born prematurely due to the trauma. The other died inside because the mother died before it could be born.
So he killed her.
Yes, he did. He was charged with homicide with unintentional abortion. It's a complex crime because one single set of violent acts violated two distinct legal interests: the life of the woman and the life of the fetus.
And what if she was his wife instead of a stranger?
Then it legally becomes parricide with unintentional abortion. The penalty for parricide is the highest in the chain, so that would absorb the overall severity of the punishment.
Okay, let's pivot for a minute to the person we haven't really talked about as the main perpetrator yet, the pregnant woman herself. Section 4, Article 258.
Abortion practiced by the woman herself or by her parents.
So if a woman induces her own abortion or actively consents to someone else doing it to her, she falls under this specific Article 258.
Right. And it is very important to note the clear distinction in liability here. Let's say you, the host, help me, the pregnant woman, have an abortion. I am punished under Article 258 as the woman, and you are punished under Article 256 as the outsider.
Who typically gets the harsher sentence in that scenario?
Usually the outsider does. The law historically views the woman as somewhat of a victim of circumstance, or perhaps just less culpable than the abortionist who facilitates the act.
And we actually see that dishonor clause come back here too, don't we?
Yes, we do. If the woman does it specifically to conceal her dishonor, her penalty is mitigated. Again, this is the law heavily recognizing the immense social pressure of shame.
But what about her parents in this scenario? If my parents look at me and say, we have to get rid of this baby to save the family name, and they make me get an abortion.
This is where the source material gets a little dense, bordering on contradictory, actually. One interpretation, provided by Reyes, suggests that unlike infanticide, where you'll remember the grandparents get a clear mitigation, parents who cause an abortion, even with the daughter's consent, do not get the same mitigation.
Wait, hold on. So for infanticide, which is killing a fully born baby, the grandparents get a break for hiding shame. But for abortion, killing a fetus, they don't get the break.
Reyes argues exactly that. He notes, quote, no mitigation for parents unlike an infanticide. However, if you look at Article 258, paragraph 3, it specifically mentions parents acting with consent to conceal dishonor. So it seems to suggest there's a specific legal lane for them, but it is definitely treated differently than the broad automatic mitigation found in the infanticide statutes.
It feels like the law is just deeply confused about who it wants to blame more. Is it the family trying to hide a dirty secret, or is it the actual act of stopping a pregnancy itself?
It perfectly reflects the deep tension between protecting life and protecting family reputation, which were historically the two massive pillars of this old Spanish-influenced code.
Speaking of pillars of society, let's move on and talk about the people we literally trust with our lives. The doctors. The midwives. Section 5, Article 259.
The professionals. This specific article deals with physicians and midwives who actively abuse their science.
The source notes say they receive the maximum period of the penalty. Why so harsh?
The commentator Albert puts it rather poetically. He says they have a heavier guilt because they are actively making use of scientific knowledge that is strictly meant for the preservation of life to instead destroy it.
It's basically the ultimate betrayal of the Hippocratic Oath.
Exactly that. But there is a crucial constraint to this rule. They must have actually taken advantage of their specific skill.
What does that mean practically speaking?
Well, let's say a doctor gets into a bar fight or a domestic dispute with a pregnant woman and punches her in the stomach, causing an abortion. He didn't use his advanced medical skill, he just used brute physical force. So he would be punished exactly like any other ordinary person under Article 256 or 257. The aggravating circumstance of being a physician doesn't apply to him there because he didn't act as a physician.
Ah, I get it. So he actually has to use his scalpel or his intimate knowledge of drugs or perform a specific medical procedure to get that maximum penalty.
Correct. It's entirely about the abuse of the specialized craft.
And then we have the pharmacist down in paragraph 2.
Yes, Article 259, paragraph 2. This is honestly scary for any working pharmacist.
Yeah.
The core crime is dispensing an abortive without a proper physician's prescription.
Just literally handing over the pill across the counter.
Yes, and here is the real kicker. The source says the absence of knowledge that the abortive would actually be used to cause an abortion is totally immaterial.
Wait a minute. So if I'm a pharmacist and I sell a drug that can be used for abortion, but maybe it has other totally normal uses, like treating stomach ulcers or something, and I sell it without a prescription and the person goes home and uses it to abort the pregnancy, I'm legally liable, even if I genuinely thought they just had a bad ulcer.
You are fully liable under this article. Because the crime isn't causing the abortion. The crime is the dispensing without a prescription. The law essentially says these drugs are highly dangerous. Your specific job is to gatekeep them. If you open the gate without the right key, the prescription, you are legally responsible for whatever comes through.
That is strict liability. There's no wiggle room.
It gets even worse for them. What if the pharmacist actually did know it was for an abortion?
Then they are considered an accomplice.
Yes. Then they aren't just liable for the lower crime of dispensing. They become a full accomplice to the abortion itself, which carries a much different, often much higher or more complex level of liability.
Wow. Okay, this brings us to the final piece of legislation mentioned in our deep dive notes. Republic Act number 4729. This one specifically regulates contraceptives.
Yes, this law regulates the overall sale and distribution. It categorically declares it unlawful to sell or distribute any contraceptive drugs or devices unless you are a legally licensed drugstore or pharmaceutical company.
And it gives us some interesting definitions. What is the actual legal difference between a drug and a device in this specific context?
It is basically biological versus mechanical. A contraceptive drug is legally defined as a medicine or potion used exclusively for preventing the fertilization of the female ovum, so it works chemically inside the body.
And a device.
Contraceptive device is defined as any instrument or material that is physically introduced into the female reproductive system for the primary, express purpose of preventing conception.
Like an IUD, for instance.
Exactly like an IUD. The law carefully distinguishes them by mechanism, but it regulates the sale of both extremely strictly. You absolutely can't just sell these things on a street corner.
So if we step back, we've really covered the entire timeline today. From preventing conception with RA 4729, to ending a pregnancy with abortion laws, to killing a newborn with infanticide laws.
It is a full, comprehensive spectrum of legal liability.
So what does this all mean for us today? When we step back and look at this massive mosaic of laws and cases, what are we actually seeing?
I think we are seeing a legal system that is obsessively trying to categorize human tragedy.
Yeah.
Think about the wide spectrum we just discussed. On one far end, you have the truck driver. He has absolute zero malice. He's just a terrible driver.
Right.
But because his pure negligence stopped a potential life, the heavy hand of the law steps in.
Right.
On the other extreme end, you have the doctor. Highly educated, sworn by an oath to save lives. If he deliberately uses that specialized knowledge to end a pregnancy, the law comes down and hits him the absolute hardest.
And right in the messy middle, you have the mother.
The mother really is the most complex figure here. The law acts almost bipolar toward her. It strictly punishes her for the act, but it also creates these massive, glaring loopholes, like concealing dishonor, that explicitly acknowledge her deep suffering and the crushing weight of social shame. It's a very human, albeit incredibly grim, acknowledgement that society puts immense, sometimes unbearable pressure on women.
It really highlights how the law isn't just a cold calculator. It's desperately trying to measure abstract things like honor, reputation, viability, and skill.
And time. You can't forget the time aspect.
Yeah.
That strict 72-hour window in Article 255, it forcefully suggests that legally speaking, a baby that is exactly 2 days old is an entirely different category of victim than a baby that is 4 days old. That is a purely legal fiction, obviously, but it has literal life or death consequences for the accused standing trial.
It's the utter precision that scares me a bit. You think you know what murder is. You think it's black and white. But then you realize that if you used a gun instead of a glass bottle, or if the baby was exactly 73 hours old instead of 71, the entire criminal charge changes completely.
That is just the inherent nature of criminal law. It meticulously requires elements. If even one element is missing, like physical violence in that 1887 gun case, the entire crime dissolves or completely changes shape.
Which actually brings me to a final thought for our listeners to mull over as we wrap up. We talked at length about that 1887 ruling, the man who pointed the gun at the pregnant woman. The court said no physical touch, no violence, therefore absolutely no abortion charge.
Yes.
But in 2026, we know so much more about the brain-body connection than they did in 1887. We know for a medical fact that extreme terror releases massive amounts of cortisol. It causes severe vascular constriction. It can literally physically force a body to reject a viable pregnancy.
We absolutely do know that now.
So if you're listening to this, ask yourself, does that 1887 ruling still hold water today? If the legal definition of violence is essentially force, isn't psychological force just as physical in its actual effects on the human body?
That is the ultimate question. The law evolves very slowly, often much slower than medical science does. But it really raises the issue. Are legal definitions of force and violence simply too tangible in a modern world where we actually understand the incredibly tangible, destructive power of the human mind?
It is definitely something to think about next time you read a news headline about someone getting off on a legal technicality, because sometimes that technicality is just a 150-year-old definition of a single word like force.
Indeed it is.
Well, thanks for diving deep with us today. This was a heavy one, but a necessary one to unpack. We'll see you all on the next deep dive.
Stay curious out there.
Welcome to The Debate. Today we are opening a particularly heavy door. We're stepping into the shadowy intersection of biology, morality, and the Revised Penal Code to examine the destruction of prenatal and neonatal life. Specifically, we're looking at the razor-thin legal distinctions between infanticide under Article 255 and the various forms of abortion under Articles 256 through 259.
Yeah, it is a subject that is as fascinating as it is deeply disturbing. When you really sit down and read through these articles and the accompanying case law, you realize we aren't just talking about the act of killing. We are talking about how the law measures the value of a life based on a stopwatch, reputation, and sometimes the specific way a person is terrified.
Exactly. And the central question we are tackling today is this. Does the strict legal demarcation between a fetus and an infant, and specifically the 72-hour rule found in Article 255, along with the concept of concealing dishonor, does this create a necessary framework of justice that protects the accused from unfair presumption? Or does it produce moral inconsistencies where penalties rely more on the timing of the act than the gravity of the act itself?
I think you know exactly where I stand on this. I represent the view that the code, in its attempt to categorize these tragedies, relies on archaic contradictions. We are looking at a system where honor operates as a discount coupon for murder, and where the definition of violence lets aggressors off the hook on technicalities that just completely ignore how the human body actually works.
And I naturally take the opposing view. I argue that these distinctions, viability, independent life, strict time frames, these are not merely technicalities, they are essential legal safeguards. They acknowledge human frailty, the physiological reality of birth, and the incredibly heavy burden of proof required by the state. We cannot legislate based on emotion. We have to legislate based on provable facts.
Well, let's test that theory right away. Why don't you start by laying out why you think this rigid distinction of infanticide, this 72-hour rule you mentioned, is actually a good thing?
Gladly. Let's look closely at Article 255. Infanticide is defined specifically as the killing of a child less than 3 days or 72 hours of age. Now, to the layperson, killing a baby is killing a baby. A life is a life. But the law must be clinically precise. The core of my argument rests on the burden of proof established in cases like U.S. versus Aquino. The Supreme Court held that the prosecution must prove the child was born alive.
Right, but alive seems like an incredibly low bar, doesn't it? I mean, if the baby's out and breathing, it's alive.
Not in a strict legal sense, no. Alive here means fully developed and capable of independent life. This is crucial because childbirth is a traumatic, highly dangerous biological event. If a mother gives birth and the child is stillborn or dies seconds later due to natural physiological complications, she cannot be held liable for infanticide.
Without the strict requirement to prove the child was a living creature completely separate from the womb, we risk imprisoning grieving women for natural tragedies. The law presumes innocence. And in this specific window of time, these first 3 days, the line between life and death is often medically blurry.
I understand the need to protect against false accusations regarding stillbirths. That makes sense. My issue isn't with the requirement of life. It's with what happens when the killing is definitively intentional. I am talking about the concealing dishonor mitigation in Article 255. The law effectively says, if a mother or even the maternal grandparents kill this newborn within 72 hours to conceal their dishonor, the penalty is lowered. You are defending a statute that explicitly places the social reputation of the family above the life of a breathing child.
I think you are mischaracterizing the fundamental intent of the law there. If we look at the commentary from Viada, the mitigation isn't about valuing reputation over life in a moral sense. It is a recognition of a very specific psychological state. Viada describes it as acting under excitement and obfuscation. The mother is in a state of sheer panic, acting solely out of fear, lacking the time to reflect on the gravity of her actions. It creates a necessary legal distinction between a cold-blooded murderer and a terrified woman making a tragic split-second error in judgment.
See, I just don't buy that. If we are going to talk about honor, we have to look at the ugly underbelly of that concept. Look at the ruling in the Albert case. The law states that a delinquent mother who kills to avoid dishonor must be of good reputation to even qualify for the mitigation. Albert explicitly states that a prostitute is not entitled to the lesser penalty because, and I bloat the material here, she has no honor to conceal.
That is the application of the law, yes.
But think about what that implies. It implies that the life of the child matters less if the mother is deemed respectable by society. It creates a legal fiction where moral culpability shifts entirely based on the sexual history of the mother. It's not about the baby, it's about the mother's social standing. If a prostitute kills her baby out of panic, she gets the full weight of the law. If a debutante does it, she gets a pass. That is the very definition of arbitrary.
I see why you think that, but let me offer a different perspective on that specific ruling. The law is not judging the value of the child's life as less. It is judging the intent and the motive of the offender. Criminal law is always about the intersection of the act and the intent. In the case of the prostitute in Albert, the court is saying that the specific motive of fear of social ostracization cannot logically exist if society has already ostracized her. Therefore, her act of killing cannot be mitigated by that specific fear. She is treated more harshly, like a regular murderer, because she lacks that legally defined psychological mitigator. It is a harsh logic, I will readily admit, but it is internally consistent with the theory of mitigation.
Internal consistency doesn't make it just. But let's move to the mechanism of the killing itself, because this is where the 72-hour rule really starts to break down for me.
The 72-hour window is a bright-line rule. It provides necessary certainty in the courtroom.
It's a cliff. It's not a line. Let's look at the timeline logically. If a mother kills her child at hour 71, it's infanticide, potentially mitigated by dishonor. She faces a lower penalty, perhaps a few years. But if she kills the child at hour 74, just 2 hours later, it becomes parricide. Parricide carries a penalty of life imprisonment to death. Are we really suggesting that the psychological pressure of a terrified new mother magically dissipates the moment the clock strikes hour 73?
Well, the law has to draw a line somewhere. We see this in all aspects of law: age of majority, statutes of limitations. The 72-hour window is deemed the period of immediate postpartum crisis. It is the window where the physical and hormonal toll is at its absolute peak. After 3 days, the legal presumption is that the mother has had time to rest, to feed the child, to bond. The blind panic defense simply becomes less medically and logically credible.
But it overlaps with abortion in a way that creates a complete paradox. Let's look at the definition of alive again. You mentioned U.S. versus Vedra earlier.
Yes, Vedra is a foundational case for forensics. In that instance, a mother gave birth, took the infant, and buried it nearby. The child was found dead. The defense argued the child was born dead, but forensic evidence showed abrasions on the nose,
Right. Abrasions caused by external pressure.
Exactly. That pressure caused suffocation. This scientifically proved the child was born alive and was killed by an external act. That is the justice system working, science proving the crime. It wasn't about reputation there. It was strictly about the physical evidence on the body.
I agree that Vizada shows the importance of forensics. I'm not disputing that. But compare that exact scenario to Article 256, intentional abortion. The syllabus notes that a fetus is generally considered the stage before the 6th month, or the term of viability. But the ADA notes that even if a fetus is full term, 9 months, ready to be born, if it is killed in the womb via violence or drugs, it is abortion.
Correct.
So here is the absurdity of the framework you're defending. If a mother takes a drug to kill the fetus 5 minutes before birth, it is abortion. If she waits 10 minutes until the baby is out and then suffocates it to hide her shame, it is infanticide with mitigation. The physical act of killing, the destruction of life, is virtually the same. The intent to get rid of the child is the exact same, but the penalty swings wildly based on whether the baby has taken a single breath.
That is a compelling argument, though I would frame it entirely differently. You are collapsing two completely different legal interests into one. Abortion is a crime against the potentiality of life and the safety of the womb. Infanticide is a crime against a person. The law treats them differently because the status of the victim has fundamentally changed. Once that child takes a breath and has an independent existence, they are a person under the law.
But if the status changes to person, shouldn't the penalty logically go up? Yet, because of the honor mitigation in infanticide, it effectively goes down compared to parricide. It feels like the law is inadvertently incentivizing the mother to wait until birth if she wants to claim dishonor.
That is an incredibly cynical reading of human behavior. No one is consulting the penal code in the delivery room.
Perhaps not consciously, but the structural inconsistency remains. And speaking of inconsistencies, look at the difference between parents in infanticide versus abortion. Article 255 allows maternal grandparents to use the concealing dishonor excuse to get a lower sentence. But look at Article 258.
Article 258 covers abortion practiced by the woman herself or by her parents.
Exactly. If parents cause an abortion with their daughter's consent to conceal dishonor, Reyes explicitly states in his commentary there is no mitigation. Why does the law have sympathy for a grandfather suffocating a newborn to hide shame, which is infanticide, but no sympathy for a grandfather paying for an abortion to hide that exact same shame?
Because of the element of time and reflection. This is the absolute crux of the distinction. Infanticide, by its nature in the code, presumes a sudden, highly reactive state. The baby is suddenly here, the physical reality sets in, the panic peaks, the act is committed. It is a crime of passion in a sense. Procuring an abortion, however, implies premeditation. You have to find a doctor, or a midwife, or secure a drug. You have to actively plan it.
Even if that planning is driven by the exact same suffocating fear of dishonor?
Yes, the law has always punished premeditation more severely than impulsive acts. The lack of mitigation for the parents in Article 258 reflects that they had time to think, time to stop, and yet they proceeded with the destruction of the fetus. In infanticide, the law concedes that the grandparents might be acting in the same immediate blind panic as the mother.
It really feels like splitting hairs to justify a double standard. But speaking of splitting hairs, we absolutely have to talk about the concept of violence in unintentional abortion, which is Article 257. Because this is where the law feels completely stuck in the 19th century.
Article 257 covers cases where violence is used on a pregnant woman, but without the specific intent to cause an abortion.
Right. And you have this ruling from the Supreme Court of Spain from 1887, which is still heavily cited in our jurisprudence, that says pointing a gun at a pregnant woman who then miscarries out of fear is not abortion.
Because no physical force was used against her body.
That is ludicrous. If I put a loaded gun in a pregnant woman's face and the sheer terror causes her body to violently reject the pregnancy, I have caused the death of that fetus just as shortly as if I had physically punched her. But the law says, well, you didn't touch her, so it's just grave threats.
But it comes down to the strict interpretation of criminal statutes. Violence in the penal code implies actual physical force, vis physica. The law is highly hesitant to draw causal links between purely psychological stressors and physical outcomes like miscarriage, because that opens a Pandora's box of liability. If I shout at a pregnant woman in traffic and she miscarries, am I liable for unintentional abortion? If I fire her from her job and the stress causes a miscarriage? The requirement for actual physical violence acts as a necessary limiter on endless liability.
But we aren't talking about shouting in traffic. We are talking about pointing a lethal weapon.
But look at the case of People versus Solifrania. This was a case where the accused actually boxed a pregnant woman on the stomach and strangled her.
See, that is definitely physical violence.
It is, but even there, the court had to be incredibly careful. They held that his violent actions indicate an intent to kill a woman, not necessarily an intent to cause an abortion. The law requires us to be very specific about what the criminal actually intended to do. If we simply say, the baby died, so you are automatically guilty of abortion, we are applying strict liability to a situation that strictly requires criminal intent. The advocate in me upholds that we cannot punish someone for a crime they didn't intend to commit, unless it clearly falls under reckless imprudence.
But Jeffrey. The case of U.S. versus Jeffrey. The accused maltreated a woman, supposedly not even knowing she was pregnant at all. She miscarried. He was held fully liable for unintentional abortion.
Exactly. That proves my point perfectly. In Jeffrey, there was physical violence. He struck her with a bottle. That physical act allows the law to scientifically bridge the gap. He committed a felonious act of assault, and therefore, under the law, he is responsible for all the direct consequences of that act, even if he didn't know she was pregnant. But without that physical contact, without that base felonious act of physical violence, you cannot legally bridge the gap to the miscarriage.
I suppose I just find the legal definition of violence to be dangerously narrow here. It ignores the modern medical reality that psychological terror can be just as physically damaging as a fist. But there is one area where the law is shockingly broad, and that's Article 259, the professionals.
Ah, the physicians and pharmacists.
Yes. Under Article 259, a pharmacist who dispenses an abortive without a proper prescription is criminally liable. And Reyes notes in his texts that the absence of knowledge that the abortive would be used for abortion is immaterial.
Correct.
So let's play this out in the real world. A pharmacist sells a drug that can be used as an abortive. Maybe it has other common medical uses, but the customer doesn't have a prescription. The pharmacist assumes it's for an ulcer. It's then used for an abortion. The pharmacist is now criminally liable for the abortion. That is strict liability on steroids.
It is strict, yes, but it is entirely necessary. We are talking about the gatekeepers of lethal substances. The law imposes a heavier guilt on physicians and pharmacists because, as Albert points out in his commentary, they possess specialized scientific knowledge. That knowledge is meant for the preservation of life. When they allow it to be used for destruction, either through active malice or through simple negligence in checking a prescription, they have betrayed their profession and endangered the public.
But to punish them when they genuinely didn't know? That seems to defy the basic legal principle of criminal intent.
They should have known to ask for the prescription. That is the crime. The dispensing without the proper prescription is the exact act that endangers society. If they follow the rules, if they demand the paperwork, they are completely safe. This isn't about punishing an innocent mistake. It's about enforcing a critical checkpoint. If we allow pharmacists to say, "I didn't know," while handing out restricted drugs, the regulations become totally toothless. They are the first line of defense.
It puts an incredible burden on the dispenser. And speaking of burdens, let's look at the stranger element one last time before we wrap up today. We talked about mothers and grandparents mitigating their sentences, but People versus Jaka and Rasahalan brings up the stranger.
Yes, when a person other than the mother or grandparent kills the child.
Right. Even if this stranger is actively helping the mother conceal her dishonor, say a loyal maid or a close friend, they get slapped with a full murder charge.
Correct. U.S. versus Aquino reinforces this principle as well.
But doesn't that just absolutely prove my point about the law being disjointed? Two people commit the exact same physical act at the exact same moment for the exact same reason to conceal the mother's dishonor. One gets a mitigated, much lower sentence, like the grandmother. The other gets a murder charge, like the maid. The act is identical. The justice is completely unequal.
It proves that the law specifically targets the biological and psychological bond. The mitigation is a concession to the specific breakdown of maternal instinct, or the familial shame that the law presumes naturally exists for blood relatives. A stranger, a maid, a friend does not have that biological burden. They are expected to be the objective, rational actor in the room. When they participate in the killing, they're not acting out of blind panic in the same biological way. They are making a calculated choice to assist in a murder. The law rightly punishes that calculated choice.
Ari, it arbitrarily protects bloodlines while throwing the book at bystanders. It creates a caste system of culpability where who you are matters more than what you did.
I suppose that is where we fundamentally disagree. I see a framework that is trying its best to account for human nature and biological reality. You see a framework trying to enforce a social hierarchy.
I see a framework that desperately needs an update.
Which naturally brings us to our conclusion. As we review these articles 255 through 259, I maintain that while the distinctions of the 72-hour window, the strict requirement of physical violence, and the legitimate honor clause seem rigid, they provide a necessary scaffold. They allow the courts to cleanly distinguish between premeditated malice, accidental tragedy, and acts born of desperate hormonal panic. The law cannot adjudicate morality in a vacuum. It can only adjudicate proven facts, like the physical abrasions in Vedra or the missing prescription in Reyes.
And I maintain that a system where a prostitute receives a higher penalty than a reputable woman for the exact same crime, or where psychological violence causing a miscarriage goes unpunished, is a system that is prioritizing rigid definitions over actual justice. The edge cases we discussed today, the 74th hour, the terrified miscarriage from a gun, these reveal the deep cracks in the code. We are regulating life and death with a rulebook that often feels like it values the reputation of the mother far more than the survival of the child.
It is certainly a heavy topic, and one that reveals just how much the law struggles to cleanly categorize the immense complexity of fetal and neonatal life.
Absolutely. And honestly, we didn't even touch on the full complexity of the contraceptive definitions in other Republic Acts, which is a whole other debate for another day.
Indeed it is. We invite you, the listener, to read the specific case notes in the source material we discussed today. Look up U.S. versus Vedra. Read the tragic details of U.S. versus Jeffrey. Decide for yourself if the line drawn by the law is a protective wall or a stumbling block.
And ask yourself, does the clock really determine the value of a life?
Thank you for joining us on The Debate.
Until next time.